do we then allow that to proceed? The answer is provided in a case I've shared with my friends here, and I brought extra copies for the court. This is the case of Omega Enterprises Kenya Limited versus Kenya Tourist Development Corporation and two others, reported at 1998 EKLR. In those days, the paragraphs were not numbered, but I'm referring to a passage at page 6 of 13. And this is what it says. If an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more ado, though it is sometimes convenient to have the court declare to be so. And every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. There's a second paragraph you'll find at the top of page 7. I will not read it, but where the judges there in the Court of Appeal said that anything done in violation of a court order, and in this case a constitutional provision, is a complete nullity, since with such a faulty foundation, the entire house of cards must collapse with much ado. Allow me to say this. In 2014, I believe it was June, July, the Honorable Justice Mombingogi, as she then was, stopped the Senate from deliberating on the impeachment of Governor Kivutha Kibwana. That decision is not reported. I've not been able to find it. These proceedings are being hurried at the Senate, the National Assembly, but the court with resources will be able to get that decision. The Senate was stopped from deliberating the impeachment of Governor Kivutha Kibwana in 2014 June. There is precedent for what you're being asked to do. Thank you for the privilege of your attention and for your time. Thank you.
Thank you very kindly, my lords. I stand to urge my notice of motion dated the 30th of October, supported by supporting affidavit, and a further affidavit, your lordships, dated the...
Your motion is dated?
The 30th of September. And a further affidavit, your lordship, filed before this court, dated the 9th of October. Your lordship, permit me to draw your attention to paragraph 15 and paragraph 20 of my motion, which form the basis upon which Justice, your brother Justice Mugambi considered when bringing this matter for empowerment.
That is of the affidavit.
That's on the affidavit and the notice of motion. Your Lordship, those are the grounds upon which we urge that this application qualifies under the case of Peter Katrao Munya to have met or to have gained the grounds of forming a prima facie case. Subsequent to which, your Lordship, a conservatory order can ensue. Further to that, your Lordship, the question of public interest, your Lordship, in this matter is paramount. To the extent, your Lordship, the petition is seeking to look or to protect and uphold the Constitution under Article 3 of the Constitution. Your Lordship, while granting the order sought, consider the paragraphs 7, 8, 9, 10, and 11, and 12 of my affidavit. And your Lordship, you confirm that this is one of the applications that meets the threshold in the case of Peter Katrao Munya. Your Lordship, permit me to associate myself with the submissions made by my senior learned friends, but also invite your Lordship not to tie yourself to the traditional doctrine of separation of power as expounded by Montesquieu. Your Lordship, the current constitutional dispensation in regard to separations of power, your Lordship, has lost its virginity as it was described by Montesquieu. In the sense that, your Lordship, this new constitutional dispensation has put the people at the middle of all government organs functions. And your Lordship, when the people were enacting Article 10 of the Constitution, they enacted Article 10 in mind of holding organs, be it judicial organs or parliamentary organs, accountable to the people of the Republic of Kenya. And those organs are being dictated that they must observe the rule of law as and when they cease to dispense with their functions. That is to mean, Your Lordship, if Parliament failed to abide by the Constitution, then the functions or what ensues therein after is subject of interrogation and review by this Honorable Court. That is to mean, Your Lordship, that the doctrine of restraint cannot be viewed on a straight jacket. It must be viewed on case-to-case basis. That is to mean, Your Lordship, if an organ has violated the Constitution in pursuit of its functions, then this court cannot hide behind the veil of judicial restraint. Your Lordship, permit me to invite you to look at the case of the Speaker of the Senate and the Attorney General.
Just for emphasis, are you saying that the doctrine of separation of powers is no longer applicable in our Constitution? That power is given to the people?
Not as described by Montesquieu.
Can we expound this?
Your Lordship, Montesquieu speaks that these three arms of governments must operate distinctively and independently. But Article 165 of the Constitution, 3(2)d, has given you the power to interrogate the functions of any organ in this republic. That is when the separation of power lost its virginity. Your Lordship, permit me to invite you to look at the case of the Speaker of the Senate versus the Attorney General, 2013 EKR. And the Supreme Court is saying, we would state as a legal and constitutional principle that courts have the competence to pronounce on the compliance of a legislative body with the process described for the passing of a legislation. In this case, the process for the impeachment of the Deputy President of the Republic of Kenya. These courts have the competence to interrogate and even issue an order to preserve the process. Your Lordship, the courts are saying in the case of Doctors for Life that when the courts are to intervene, the courts will look at the consequences of the actions being sought to be restrained. For this case, Your Lordship, if the impeachment is to be allowed to proceed, it will culminate into the violation of the Deputy President's rights under Article 38. This process have the ability to limit the rights under Article 38. Whereas Article 38 says that if you are elected, you have a right to hold that particular office. That is to mean, Your Lordship, that if Parliament and the Senate is to limit the rights under Article 38 of the Deputy President, the same must qualify under Article 24 of the Constitution. It must be reasonable, it must be lawful, it must be justifiable, it must be acceptable in a just and a democratic society. Finally, Your Lordship, I invite you to look at the case of Commission for the Implementation of the Constitution by the National Assembly, again 2013 EKR, and also, Your Lordship, invites you to look at the case of Martin Nyaga Wangora, a matter that we urged with my senior counsel. The courts are saying that judicial restraints must not, however, be an excuse for the dereliction of constitutional duties. If the court has been empowered to conserve a particular situation so as to inhibit the violation of the Constitution under Article 258 of the Constitution, then the court cannot fold its hands to that particular constitutional duty. It's my humble submission, Your Lordship, that this is one of the cases that the court can issue conservatory orders. London is not burning. The Senate is not wasting away. Your Lordship, I urge you to uphold my motion and grant the conservatory orders as sought. But as you do so, Your Lordship, also look at the famous case of Marbury versus Madison. Further that, Your Lordship, for Doctors for Life is also a relevant case for your consideration. That is 206. The courts are saying that as long as you have gone outside your constitutional ambit, this court can uphold the Constitution, should rise and protect it under Article 3 of the Constitution, and most importantly, uphold the supremacy of the people. In what sense, Your Lordship? That public participation was never done. And even as we wait tomorrow, Your Lordship, it is going to be done in the absence of public participation. This court will take judicial notice that the Senate, as it sits tomorrow, it has not called the people of the Republic of Kenya, pursuant to Act 118 of the Constitution, to conduct public participation. There is no one who is immune from judicial scrutiny. Not the Senate, not the National Assembly, not ourselves. Your Lordship, penetrate the doctrine of restraint, the judicial restraint. Let this court penetrate it. Most obliged.
Your Lordship. So in effect, Mr. Ndegwa, your application substantially is the same as Senior Counsel Rute's application.
Yeah, precisely. Only that mine is done by Mwananchi, who is asking the court to penetrate the doctrine of restraint.
Yeah, yes, right. My application is dated 6th of October 2024.
Counsel,
Yes, Judge.
your name?
Okila Waduta. Sorry, Judge.
Mr. Kirago Nduta.
Waduta. For the second petition. Yeah, I wish to associate myself fully with the submissions by. My matter is 537. 6th of October 2024. I wish to associate myself fully with the submissions which have been made by the three councils who submitted before me. And the application is similar to theirs. Say that, my Lord, I want to submit only on one prayer number 9, that this court grants any further orders that this honorable court deems fit in the interest of justice. I will argue only one that prayer. The facts that support this application, and indeed the petition, are not controverted. The application was not replied to.
There's no response to that application.
There is no application made. There is no response made. One of those facts is that prior to the debate in the National Assembly, the Speaker of that Assembly, as well as the Deputy Speaker, on different occasions pronounced themselves that they support the impeachment motion. Article 50 of the Constitution requires that a person is entitled to fair trial, which includes that such a trial before a court or anybody must be done by a body that is impartial. Under Article 25, that right cannot be limited at all. Therefore, the proceedings that took place before the National Assembly fall short of Article 50 as read with Article 25. I do not wish to repeat what my learned senior, Mr. Tom Masharia, submitted, but actions that are contrary to the constitutions are unconstitutional and therefore need to be declared null and void. So, in arguing the prayer for the appropriate remedies, Article 145 on the process of impeaching a president, which is the same process that is for impeaching a deputy president, Sub-Article 7 of Article 145 provide that these are the tail end of the process before the Senate. If at least 2/3 of all the members of the Senate vote to uphold any impeachment charge, the president shall cease to hold office, and in this case, the deputy president, because that provision applies mutatis mutandis. So, in the event that the process of impeaching the deputy president goes on and he is eventually impeached, my lord, this court still has power to make an appropriate remedy to prevent further violation of his rights. And those are the rights that we have described in our application and our petition. What is that appropriate remedy, my lord? In the case of David Ndii and others versus the Attorney General and others, it is 2021 EKLR. That's the BPI case. A 5-judge bench considered the question of an appropriate remedy. And that appropriate remedy is traced at Article 23 of the Constitution. That is sub-Article 3 of Article 23, where it says, in any proceeding brought under Article 22, a court may grant appropriate relief, including a declaration of rights, an injunction, a conservatory order. And in that case, the court gave the reasons, and the outcome in this case was that, fine, let the process go on. But at paragraph 44, allow me to read how the court concluded in that case. Accordingly, the order which commends itself to us as the appropriate relief in the circumstances to preserve the subject matter of the consolidated petitions, and which we hereby grant, is that the assent contemplated at the article the assent contemplated at Article 256, sub-Article 4 of the Constitution, if it were to be given to the Constitutional Amendment Bill 2020, shall not come into force until the determination of these consolidated petitions. So, if the Senate were to proceed with the impeachment motion and conclude it and confirm the impeachment, my Lord, the appropriate relief would be to stay that impeachment until the consolidated petitions are heard and determined. And that is what court found in that decision. Yes, Judge.
So, in other words, you are telling us that you are submitting that the appropriate remedy, which is found under your paragraph 9, any other remedy which this court deems fit to grant, is if the orders that are sought by my learned friends are not granted, then you look at our prayer. Application is, your prayer is forward-looking.
Yes, we had similar prayers like
it is forward-looking after the event.
Yes.
It considers possibilities after the event.
Yes.
So you are going ahead and saying in the event.
In the event. But I still associate myself with my learned friends. But if you get beyond that, look at our prayer number 9 and stop the implementation of that impeachment that may arise from those proceedings. Is my time? Thank you. Thank you.
My lords and my lady, on behalf of the 8th petitioner, my name is Simon Guru. I urge the application dated the 2nd day of October 2024. The same is supported by the affidavit.
In which filing?
The application, my lord, is supported by the affidavit of John Mugokirago, and the gravamen of the petitioner is purely on the issue of public participation, which forms the basis upon which the National Assembly failed to follow the due process of the law, and in doing so, I submit that the National Assembly issued directions for public participation after having arrived at the decision to impeach the Deputy President of this country, thereby denying the great citizens of this country an opportunity to make decisions at the formative stage of that impeachment motion. It is not in dispute that after the impeachment motion had been tabled at the floor of the House, that is when directions to conduct public participation by the National Assembly were issued. I further submit, my lord and my lady, that directive did not provide sufficient information to the public about the decisions that the representatives were taking on their behalf. This denied the citizens an opportunity for intelligent and informed responses and hindering or making the public not engage in meaningful public participation. The other issue, my lord and my lords and my lady, is that the directions to conduct public participation after tabling the motion did not give adequate time to consider the information contained in the motion, and I submit that this is the same for the time to consider the responses from the members of the public. And in so doing, the public participation report that was tabled in the floor of the National Assembly cannot be said to have been considered in arriving at a decision of impeaching the Deputy President. My Lord, in that submission, I'm guided by the provisions of Article 2.4, Article 4, Sub-Article 2 of the Constitution. And this is in respect to the provision that Kenya is a multi-party democratic state and it's founded on national values and principles of governance as provided for under Article 10. I submit then that public participation is the lifeblood of democracy. And what was done by conducting cosmetic public participation indeed violates the very tenet of a democratic state. My Lords, as I conclude, noting that that very important aspect was overlooked by the National Assembly, it is incumbent on this court to evaluate, and as it's given the power under Article 165, to look at the actions that were undertaken by the National Assembly and find that that violation indeed allows this court to issue a conservatory order in the nature sought in the application. It cannot allow blatant violations of the Constitution by other organs to go unpunished or unchecked. Lastly, my Lord, as I make my last point, is that judicial restraint cannot be a panacea for all constitutional violations by public bodies. There has to be an end when it is clear that the Constitution has not been followed. Thank you very much, Lord, for that.
Your Lordship, permit me to tender this authority. It's a journal that I relied on. It's a journal of law published in 2015, volume 35, published by Elijah Oroch Archer from the School of Law, Jomo Kenyatta University. It has the authorities that I relied on.
You shared it.
Yes, I have shared it with Mr. Milimo, equally online. I have referred him to where I can get it.
Thank you. Next.
And Your Lordship, I have highlighted the specific areas for you.
Are we through with the petitioner's side?
Maybe the interested parties who have supported this.
Well, on behalf of petition 250, 225 we have not submitted by law.
And you, what is your name?
Yes, my name is Lempa.
Proceed, please.
we are here together with you and just approval.
Mr. Lempa, we took Quora a long time ago.
Yeah, we wish to rely on our notice of motion dated and the affidavit dated the second day of October 2024, and we wish to associate ourselves with the submissions of the Land Council, Mr. Senior Council, Macharia Senior Council, Wajiro Waduta, and the gravamen of our petition.
Your petition is found in which, your application is filed in which petition?
525 of 2024.
525. Okay.
Yes. My Lord, like our notice of motion, some of the prayers that we have sought in the notice of motion have been overtaken by events because they intended to just the national assembly. But that said and done, there are still orders that can issue against the Senate. But we do not want to rehearse